So having the floor means I can stand as well, I hope.
Of course.
Thank you very much for the invitation. I'm honored to be here, and it was very interesting to hear the different points of views on the directive. And so I would like to add the German perspective, if there is something like this. I would like to start with a broader introduction, and I included the UNESCO 70 UNESCO convention in my title because this is what Germany did when we learned about the EU Commission's work of adopting a new directive or modifying the directive of 1993, because we did an analysis of what German law has, what provisions work in Germany and what provisions don't work in Germany. So this is what I would like to focus on. So there might be a lot of slides that might be repetitive, so I try to skip those because my previous speakers touched up on several aspects. But especially the last aspect in Italian law is interesting because you had the same Article 37, because EU law has the idea of a single European market, and the idea of a single European market, of course, is the free movement of goods. So because of this, you could argue that cultural goods, because this is also EU language, are part of this. But however, there's an important exception, and this is what we have to keep in mind, that Article 36 of the EU Treaty is an exception to the general principle of the free movement of goods for very good reason, because member states are allowed to protect their cultural property, their cultural heritage. So this is just as an idea, because this is how it started. And it started, we have to say, by two elements, and maybe I can, as at the beginning of my speech, I can indicate those two elements. By creating a European single market, you could, from Italy to Finland, you could move whatever you have, but of course, outside of the EU, you have to have an export license. Until the creation of the single market in the EU, of course, you have national custom authorities and you have national export license. But within the Schengen area, within the single market, this doesn't work anymore. So the EU created two acts. One is the Council regulation of 2009, but it dates back to 1992 when the single market was created. So what does it mean? It means if you want to bring a cultural object over a certain age limit, over a certain financial threshold, for example, to the United States or to Switzerland, although on this map Switzerland is part of the EU, at least it looks like. But of course, if you want to go to the Basel Art Fair, you have to ask for export license. And I will come back to this later, because why is it sometimes not working? But this is what you need. So the EU is one single market, but of course cultural objects are fragile and need protection. So we have a unified provision for exporting cultural property. So and I listed those elements. We have the annex to the regulation, and of course the annex to the regulation is still in force. The EU Commission abolished, as we heard before, the annex to the directive, but the annex to the regulation is still in force, also to keep the paperwork down. For example, if you have a painting that is, let's say, 20,000 euro, then under the regulation, you do not need an export license. But if you have a painting above 150,000 euro, this is the threshold, you do need an export license. So exporting is one thing, but of course, since the single market is unified and you don't have borders anymore and you don't have custom authorities that check whether you bring something from Italy to Austria to Germany, then to Denmark and sell it, we have the EU directive. The substantial modifications, we talked about this, but it's important to keep in mind that the directive is a kind of compensation for the free market, since member states are not able to protect their bodies anymore because of the benefits of the single market. And nowadays, you know, you cannot stress enough those benefits of an open market. But of course, you know, the national laws of protecting cultural property, they had to be compensated in terms of giving limitation to the open market, to the common market in the EU. We talked about, you know, the substantial modifications. My previous speakers mentioned them specifically. But, you know, just eliminating an annex sounds little, but in fact it's a lot. It means that no matter what Spain or Portugal or Finland protect, all other member states have to protect it. And of course, some member states, especially in southern Europe, like Greece or Italy, they protect more, and other countries, they protect less. But it's the decision of each member state how much and what they protect. But all other member states have to protect it. That's the idea by simply abolishing the annex, so it's a lot. Time limits, we talked about this. I'm not going to elaborate on this. Due diligence, you know, we had the care and attention, what it means, and due diligence. This is, you know, thanks to the UNIDROIT Convention that we have this, this concept and this idea. It's interesting that, you know, if you had an EU regulation like the one on the export of cultural property, it does not need implementation. So all member states do the same. Here we have a directive that needs implementation, which means that member states could modify due diligence. So far my impression is that most member states, of the 28 member states, basically paste and copy and take the wording of the directive, which might have the effect that for the very first time in EU law, you might have a common definition of due diligence, and this is a big thing. Of course, it now depends then on the national courts, because who is, you know, interpreting? It's the national courts. So it will be interesting in the next couple of years whether a British court or a Bulgarian court or a German or a Polish court define due diligence in the same manner. You know, court decisions are very important in this, so there might be a further elaboration on this. So having talked about due diligence, and you know, I just gave the wording, but we spoke, I think, extensively about this Article 10 of the directive. But you know, there's a reasonable person that has to do everything, and it's basically the possessor. So the possessor has to act in due diligence. Well, when we thought about how to implement this EU directive, we thought, well, poor possessor. I mean, if you buy something at the art market or at an auction, you know, you might not have the expertise. So as a possessor, you all of a sudden have to take care of the due diligence. How do I do this? You know, it's not my profession. So in Germany, what we did is, when implementing the directive, we do not only give the possessor the due diligence, the poor possessor, but also the one who sells objects, because it's his profession. So by implementing the EU directive and the due diligence, we looked at how Switzerland is doing it. And Switzerland in 2005, and I'm not saying more on this because Marc-André is presenting in Switzerland tomorrow, but Switzerland has specific obligations for the art market. So we took this idea from Switzerland, combined with the EU directive, and the German law implementing the directive will have obligations for the possessor, but also for the art market. Because it's their profession. This is how they earn their money, or they should at least. So in order to complete, this is a little bit out of the box, but I think it's part of the EU system. So we have export controls. We have within the EU, we have the return of illegally exported objects, but of course we also have, for the specific situations in Iraq and Syria, we have EU law that provides sanctions on the import, export, and trade and cultural property. So this is something very important when it comes down to protecting cultural property from these countries, and I will come back to this in 1 minute. But for the time being, we can say, because of this, we have a complete prohibition of import-export of cultural property from those two countries. Now focusing on what we did in Germany. So this is also the title that I have chosen, Recent Development in Germany. So 2016, new act to protect cultural property. And I listed those elements that we looked into. So of course, we have to implement, like all other EU member states, the new EU directive. But also, we want to improve the implementation of the 1970 UNESCO Convention. Germany ratified the UNESCO Convention quite late. We did this in 2007. We implemented this as a law of 2007, returning objects from all the state parties to the 1970 UNESCO Convention. And we had to realize that the law is not working. And we had an evaluation on this. The Parliament asked for a report of evaluation, and the result was, after have written 150 pages of evaluation, the law is not working. We have to modify it. So it's not only implementing EU law, but it's also improving the 1970 UNESCO Convention's implementation in Germany, the Hague Convention, and also the improvement of the protection of German cultural property, especially when it comes to public collections. So you see the 4 points, and for example, like Italy has a uniform law. So if you look into how cultural property is protected, what you have to do when to buy it, to export it, to import it, we create a uniform act. And this is for the very first time in Germany. We will have a uniform act which makes it easier to see how cultural property is protected. So I mentioned already the evaluation report. My section, my department, we wrote the evaluation report. It was presented to Parliament in April 2013. And the Uniform Act that we presented to Parliament is now in the first reading. Is now in the first reading, or the first reading took place on February, 18th of February, so not that long ago. There will be a public hearing in Parliament in mid-April, and we hope that there will be the entry into force of that Uniform Act in July, August 2016. So some of you might have heard about the art market in Germany going crazy about this law and criticizing it and criticizing my minister for exaggerating, for doing too much. Well, you have to be aware that Germany has not a long tradition, unlike Greece, for example, or Italy, not a long tradition of protecting their own cultural property. Until today, because this is still a draft, until today there is no provision on protecting public collections, for example, legally. So, for example, the EU directive does not apply because we don't protect our cultural property in the context of Article 36 of EU law, so it's not defined as a national treasure. So this law is doing this. For the very first time, we will extend the protection of cultural property to public collections. My minister is behind that idea because we know, also because of the Nazi-looted art discussions, that provenance is one of the fundamental elements. Due diligence in the art market is one of the fundamental elements. So I hope that this law will be, it's discussed in Parliament, of course there will be experts at the public hearing, but I hope that mid of the year we will have the entry into force, also because we are a little bit late because of the Commission. We have to implement the directive, so we really have to push for this entire agenda, because the directive is only one element, but of course the deadline that the Commission gave us, has to be met. So, just to make it very quick, due diligence provisions, I touched upon those. There is, in the draft bill, there is a provision of dealing with stolen, or the prohibition of dealing with stolen, illegally excavated, or illegally exported cultural property. I mean, this is nothing new to you, but it's something new that this is in German law. So we specifically have a provision on this. We have specific due diligence provisions for Nazi-looted art. So the art market has to have specific, has to look into databases, has to do their provenance research. We also have specific due diligence for cultural objects indicated in the ICOM red lists. And I think, Marina, it was you that mentioned the ICOM red lists, or at least you had them on your slides, because they are very important indicators of what is protected by other countries, especially by countries with a rich heritage. So we give specific importance to those ICOM red lists. And of course, cultural objects subject to EU import and export regulations. This is what I mentioned earlier on, Iraq and Syria regulation. We also, apart from due diligence provisions, we also have provisions for the import of cultural property into Germany. This is new, because so far we had the cases, someone comes from Turkey, has little nice objects wrapped in a carpet, and the customs officers, very often, they cannot do anything because so far they did not have a legal base. Now we have a provision for import controls. This is something new. But we also have a provision for the export of cultural property from Germany, and this is also what was very highly discussed and debated in Germany, because right now an art dealer that brings something to Basel or to New York, he has to ask for an export license, not because of German law, but because of the EU regulation for the export out of the single market. But we experienced many cases where the object was not brought to New York, but to London. And of course, London is part of the EU single market. The object was brought to London, rested there for a couple of weeks, and then that person asked the British authorities for an EU export license to New York. And of course, the British, sometimes they ask us, so is this protected under German law? We had to say, no, it's not protected. And then the British authorities, they checked whether this German cultural property is part of the British national treasure. Well, obviously not. And then the object was gone. So for the very first time, as most member states have, we implement an export regulation saying that it doesn't matter whether you bring something to Basel, to New York, or to London or Madrid. We have the same standard. And we will raise a little bit the financial thresholds, so we double the 150,000 euro for pictures, for example, we double it to 300,000. But in principle, this is something very new and exceptional, because by the first time we will have the same standards, and many other EU member states already have those national export license. And of course, this is totally in line with EU law, because we have Article 36, as mentioned earlier. And of course, as it is stated in the title of this conference, the return of cultural property. We want to make it very simple. Illegally exported cultural property is illegally imported. Simply as this. If something leaves Egypt, Greece, or another country, it doesn't matter, illegally, whether it's illegally excavated, whether it's stolen, it's illegally imported into Germany, and then it has to be returned. It's difficult, there might be obstacles in practice, but as a principle, it is easy than this. We don't, and of course, if you have Article 7, you know, we expand on this, but we have implementation guidelines to the 70 UNESCO Convention, and so I think it's time to have this simple but easy equation. No bilateral agreements are needed. The US has bilateral agreements implementing the 70 UNESCO Convention. Switzerland does, but we think the 70 UNESCO Convention is already an international convention. We don't need additional agreements to this. And of course, last point, I'm not going to go into detail, we also improve provisions on loans and immunity from seizure. Who is interested in this can talk to me later. But you see, we have a whole variety of aspects we want to improve with this new legislation. Last thing, what is lacking, we need an EU import regulation for cultural property. There is a joint initiative by France, Italy, and Germany putting this on the agenda at the Commission because we have import regulations for Syria and Iraq, but we do not have them for other countries. So this is something all EU member states should jointly work together, because very often it's easy to say, well, you know, it's from Jordan or it's from Yemen. It's not from Syria and Iraq. So we need a common EU import regulation at EU level because of the EU single market. You know, of course, we have national customs if you fly directly, but such provision would be needed, and it's in line with most EU member states. As we heard before, only Ireland, Latvia, and Malta are missing, and then we could have the EU-wide implementation of the UNESCO Convention. So I'm going to do this very quickly because I'm running out of time. What we need is clear and simple import and export restrictions, export certificates. We need object IDs. Of course, it's a lot to ask, but lack of inventories and photographs is very often an obstacle for return claims in another country. We need information for foreign law of customs, police, administration, and tourists. It's very important to give this information also to tourists. You know, if you go to Greece and Turkey, you should know what to take out of the country and what not. Simple as this. So let me conclude with some hope, and I think the provision on due diligence is a big step forward, and I hope that this will increase the standards in dealing with cultural property in the EU and maybe beyond. Let's see how Switzerland is reacting to this new EU development in other countries outside of the EU. Thank you very much.